Good afternoon, and thank you for joining us today. My name is Kareen Riley-Takos. I am Chief of Engagement, Standards and International Relations at Standards Australia. I would like to welcome you to today's webinar, where we'll be providing you with an opportunity to hear updates on AS 4000, our general conditions of contract. We appreciate you taking the time to be part of this discussion today. During the session, we're going to be walking you through the key changes and what they mean for professionals using AS 4000 in construction projects. I'd like to begin by acknowledging the traditional owners of the land on which I join you, the Gadigal people of the Eora Nation, and pay my respect to their elders, past and present. I also extend my respects to the traditional custodians of the lands from which you are joining us today. Before we start, a quick note that the content that we will be covering today is general in nature and it's intended for educational purposes only. It should not be relied on as formal advice, and we encourage you to seek independent professional guidance for any specific questions or circumstances. A quick note as to where you can access AS 4000 and related contracts. It can be either accessed through the Standards Australia store or through our partners, Intertech and Acurus. You also see a Slido QR code on the screen. This is where you can submit your questions at any time during the webinar. We will address as many as we can during the Q&A at the end of the session. And also, before we get into the details of the recent updates, I just wanted to acknowledge that there has been commentary and feedback we've received from industry since the publication of the standard, that we understand that the changes made in these updates, they do not address all the opportunities for improvements within AS 4000. The Standards Australia team is committed to continue to working with stakeholders to explore and progress further updates to the document as a result of this revision. So without further ado, it's now my pleasure to introduce John Cooper, who will be leading us through the next part of today's session. John is Partner in Charge Brisbane at Jones Day. He's an active member of our technical committee MB10, General Conditions of Contract, and his team has supported the committee in the technical drafting of this revision. John will be walking us through the key updates within the standard. So John, welcome, and over to you.
Thanks very much, Kareen. I've been asked to address a number of questions. It is my absolute pleasure to do that in order that we can bring everyone who's involved today up to speed with what has changed and how the change has been brought about. The first question I've been asked to address is, why did AS 4000 1997 General Conditions of Contract need to be updated? The update was necessary to reflect developments in legislation and case law since the 1997 edition. It was also necessary to contemporise language and to consolidate documents, and I'll talk a little bit more about that consolidation in respect to the formal instrument of agreement later on. It was necessary to amend the terminology and structure of the document so the contract is easier to use and read. And finally, it was necessary to keep the updates to the contract tightly focused so as not to impact the risk allocation between the parties. There were some things that were not within the scope of the ambit of the committee in terms of making changes to the contract. They were changes to risk allocation, adding clauses dealing with state security of payment legislation, adding clauses to deal with modern slavery legislation, and adding any clauses or making any changes in respect of the legislation governing unfair contract terms. What was the process that was undertaken to arrive at where we are at today? First of all, a proposal was put to Standards Australia in March 2022 and accepted by Standards Australia to carry out the update. The project to undertake the update kicked off in June 2022. Drafting took from August 2022 until January 2024. From 27 March to 29 May 2024, the document was released for public comment and comments were obtained and considered by the committee. And then finally, the committee ballot was taken in December 2024, resulting ultimately in publication of the new version of the standard on 27 June 2025. What are the major changes? By way of overview, I'm going to run through the most significant changes in AS 4000, and then I will consider some of those changes in greater detail. There's been an insertion of a formal instrument of agreement as the basis for formation of the contract, and that formal instrument of agreement provides for the inclusion of a contract sum. The document has seen a redrafting and restructuring of Clause 1, the interpretation and construction provision, with new definitions added and principles of interpretation added to make the contract easier to read. The document now includes amendments which clarify how adjustments for actual quantities of work undertaken are to be made. There has been a deletion of the previous Clause 6, which provided for the evidence of contract, and a replacement of it with a new GST clause. Clause 12.2, excuse me, of the current contract now allows for the contract to be appointed as principal contractor under work health safety legislation. The insolvency provisions have been aligned with the current legislation governing insolvency and bankruptcy. There have been significant amendments made to the dispute resolution clause to allow users of the document much greater flexibility in terms of choosing a dispute resolution forum or mechanism that best meets their business needs. And then finally, there's been the addition of a clause to deal with the Personal Property Security Act. Turning now to some of these changes in more detail. AS 4000 1997 did not contain a formal instrument of agreement. The update contains a formal instrument of agreement at the front of the document, and it contains a provision to allow for the definition of the contract sum, which must be selected as either a lump sum only, with the amount being inserted in the formal instrument of agreement, or a lump sum calculated as the sum of the products ascertained by multiplying the measured quantity of each section or item of work actually carried out under the contract by the corresponding rate for each section or item of work as set out in documents that will be listed in the formal instrument of agreement, or an aggregate of those two concepts. As I mentioned in the overview, the Clause 1, which deals with definitions and interpretation, has been amended. Definitions are now self-contained. For example, definitions like the definition of contract and defect previously referred to the meaning within a clause in the relevant clause of the contract. These have been replaced by self-contained definitions, so there's no longer a need to flip from the defined term into a particular provision to try and work out what a particular term means. Definitions have been added or changed in order to support other changes that have been made to the contract. For example, definitions dealing with the GST clause, the new Personal Property Security Act clause, and the amendments that have been made to the dispute resolution clause. Definitions of document and electronic document have been added, and these are aligned with the Acts Interpretation Act of Queensland. The definition of qualifying cause of delay has been amended to make it clearer, and the definition of site has been amended to provide for a specific area to be defined as the site in the document. The interpretation section has been made a separate subclause of Clause 1, and some new interpretation provisions have been added which deal with references to a person so that it includes an individual, firm, or a body corporate or unincorporate. A reference to legislation or legislative provision now includes any modification or substitution of that legislation or legislative provision and any subordinate legislation issued under that legislation. And a paragraph has been added to make it clear that including and includes are not words of limitation. In the previous version of AS 4000, Clause 2.5 provided for how adjustments would be made to the contract sum in the event of the actual quantities of work differing from the quantities stated in a bill of quantities or a schedule of rates. And it provided that where the principal has accepted a rate for the item, the rate shall apply to the greater or lesser quantities, provided that where limits of accuracy for a quantity in a schedule of rates are stated or were stated in item 11, the rate shall apply to the greater or lesser quantities within the limits, and quantities outside the limits shall be a deemed variation. There was considered to be some uncertainty as regards the meaning of that provision. Let me explain by way of an example. If we take as an example an item that appeared in a bill of quantities which form part of the contract or a schedule of rates stated to be 100 units, and if the contract stated in the annexure that the limits of accuracy were plus or minus 10%, then the limits would be 90 and 110 respectively. If the actual work carried out was 80 units, then it was clear that the 80 units would be a deemed variation. If, however, the actual rates were 120 units, there was some uncertainty as to whether the full 120 units would be a deemed variation, or whether only 110 of those units would be within the relevant limits of accuracy to which the applicable rates would apply, and 10 units would be a deemed variation. In order to clarify the intent of this clause, the committee decided that the clause should be amended so that it would provide that when otherwise then by reason of a direction or a variation, the actual quantity of an item of work required to perform the contract is greater or less than the quantity shown in a bill of quantities which forms part of the contract or a schedule of rates, and the principal accepted a rate for the item of work and limits of accuracy are stated in item 13, then the rate applies to the greater quantities if they are within the limits. So in my example, if they were between 90 and 110, otherwise the rates apply to the quantities up to the upper limit, that is to 110 in my example, and the quantities in excess of the upper limit will be a deemed variation. That is, in my example, the additional 10 units would be a deemed variation. And then the rate applies to the lesser quantities. In my example, if the actual quantities were 80, that would be the lesser quantities. If the actual quantity was above 90, then they would be within the limits and the rates would apply. Otherwise, the lesser quantities are a deemed variation. So in my example, if the actual quantities were 80, then the 80 units being less than the lower limit would be a deemed variation. Deletion of the previous clause 6, evidence of contract, and replacement of it with a new GST clause has been undertaken. The reason for this is that as a formal instrument of agreement has been added, there is no longer a need for a clause which deals with how the contract has come into being. Clause 6 accordingly has been deleted. In its place has been inserted a new GST clause which provides for the contract sum and all other amounts and consideration in respect of a supply made under or in connection with the contract to be exclusive of GST. And if GST is payable by a supplier on any supply made by that party under or in connection with the contract, the recipient of the supply must pay the supplier an amount equal to the GST payable in addition to any other consideration for the supply. Clause 6 also provides for the issuing of recipient-created tax invoices. Clause 12 has been amended to allow for the appointment of the contractor under the contract as a principal contractor under work health safety legislation. It provides that if item 23A in the annexure provides that this clause applies, to the extent permitted by law, the principal appoints the contractor as principal contractor for the site or relevant part of the site identified in the item, authorises the contractor to discharge the duties of a principal contractor in respect of the site or relevant part of the site as the case may be, and gives the contractor management or control of the site or relevant part of the site as the case may be, to the extent necessary to discharge the duties imposed on a principal contractor. It also provides that the contractor accepts the appointment and will discharge those duties, and to the extent permitted by law, the contractor's appointment under the clause will cease at 4 p.m. on the date of practical completion. As I said earlier, clause 39.11, which deals with insolvency and bankruptcy, has been significantly amended to align that clause with recent changes in the legislation relating to bankruptcy and insolvency. One of the biggest changes that has been made in the current version is to clause 42, the dispute resolution clause. It has been amended to allow users much greater flexibility in choosing a dispute resolution forum that best meets their needs, to change the default dispute resolution process, and instead of negotiation followed by arbitration, which was the previous default process, to provide that the default is either arbitration or litigation, and users can select from the various options. To dive into it in a little bit more detail, negotiation in either arbitration or litigation will be the default procedure, and if nothing is selected by the parties in the annexure, then negotiation followed by litigation will be the default. Another option is for the parties to choose negotiation, mediation, and either arbitration or litigation. A further option is to choose negotiation, followed by expert determination, and then either arbitration or litigation. A further option is for the parties to choose negotiation, mediation, followed by expert determination, and then either arbitration or litigation. And the final option is for the parties to choose a dispute avoidance board. The updated clause 42 provides that where the parties choose expert determination, they can choose in item 39 of the annexure to make the expert determination interim binding, in which case if either party gives a notice to the other within 14 days after receipt by the parties of the expert's determination, stating that it is dissatisfied with the determination, then the dispute that is the subject of that determination is deemed not to have been resolved, which will allow the parties to proceed to the alternative that has been chosen to resolve the dispute. Clause 44 has been added to the current version of AS 4000 to provide for personal property security interests to be registered. It provides for the parties to do all things, including provide all information reasonably required by the other party, to ensure that each personal property security interest created under the contract is enforceable, perfected, and otherwise effective, enable the other party to register any security interest arising in its favour on the PPS register with the highest ranking priority possible, including where applicable as a purchase money security interest, and to maintain that registration, and enable the other party to exercise rights in connection with any security interest arising in its favour. In addition, Clause 44 provides for the recognition of security interests in favour of the contractor and the principal by providing an acknowledgement and agreement that one or more security interests arise under the contract over the security described in item 16, that is the security provided by the principal and the unfixed plan of materials in favour of the contractor, and one or more security interests arise under the contract over the security described in item 15, that is the security provided by the contractor, the contractor in favour of the principal. But each security interest described in the clause is registrable on the personal property security register, and that the contract constitutes a security agreement for the purposes of the Personal Property Security Act. I've been asked to address whether there were any significant updates or changes made as a result of the public commenting stage. The answer to that is yes. Further changes were made to the dispute resolution clause, which I've referred to earlier, to provide for litigation or arbitration to be the default as selected by the parties, and should they fail to make a selection, for litigation to be the default. There were changes made to the definition of practical completion and clause 34.6 to make it clear that a certificate of practical completion can now state a date of practical completion which is earlier than the date on which the certificate has been issued. And there were also a number of corrections made to drafting throughout the contract. What were the benefits by way of updates to impact risk allocation, or to impacting risk allocation and dispute resolution, and what practical benefits could they offer for contractors and legal teams? In short, there has been no change to risk allocation as a result of the public comments received. The changes to risk allocation were simply beyond the scope of the review, as that scope was defined at the outset back in 2022. There have been changes to the dispute resolution clause. As I said earlier, the default procedure has been changed, and there are now more options from which the parties can select. Just to recap, the dispute resolution clause has been amended to allow users greater flexibility in choosing a procedure or forum that best meets their business needs. There's been a change to the default process, and instead of negotiation followed by arbitration, which was the previous default process, it is now either arbitration or litigation, and users can select from the options. And as I outlined earlier, there are now the 5 options that are on the slide. I've been asked to address what practical benefits could be offered for contractors and the legal teams as a result of the update. There are benefits to all users of AS 4000. There's less of a need to add clauses to deal with legislative issues. For example, GST, Personal Property Security Act, the appointment of principal contractors under the work health safety legislation. There are more options for dispute resolution. There's the inclusion of a formal instrument of agreement. The definitions are now all fully contained within clause 1, avoiding the need for the reader to jump from the definitions provision into the body of the contract to work out what a particular term means. And there is now consistency of language throughout the contract, particularly in respect of time periods. What are the critical issues for consideration for compliance and legal professionals when implementing the updated AS 4000? The main implications or critical considerations from my point of view are for the parties to very carefully read the clauses, to complete the annexure carefully, particularly with respect to the options being, or the option being chosen in respect of dispute resolution. And if the parties are going to amend the contract, to make sure that they do it in a way that deals with the interrelationship between the various clauses which might be impacted by the particular change or changes. In what ways do the updates in AS 4000 align with the recent trends in construction law, such as increased emphasis on work health and safety, new legislation to ensure the quality of building, etc.? A number of amendments have been made to deal with changes in legislation, as I've already alluded to, and changes in the law and developments in the industry. For example, new clauses have been added to deal with GST, work health safety, and the Personal Property Security Act. There have been amendment of the clauses dealing with the certification of practical completion to allow a date to be stated in the certificate, which is earlier than the date on which the certificate has been issued. There have been changes to the dispute resolution clause to allow the parties much greater flexibility in choosing options, including the ability to now choose a dispute board, or as they are sometimes called, a dispute avoidance board or dispute resolution board. What advice do I give to construction and project management teams who are transitioning to the updated AS 4000 for the first time? Not surprisingly, it's to read the clauses very carefully, to complete the annexure carefully, particularly with respect to the dispute resolution options. And if you are going to amend the contract, make sure you do it in a way that deals with the relevant interrelationship between the various clauses. What's the net benefit of the updates to AS 4000 for the industry and broader community? In my view, the AS 4000 revision is a more contemporary document. It will require less changes to deal with the changes that have been made in legislation and developments in the law, and it will also provide for much greater choice by parties with respect to dispute resolution. I'm happy to take any questions.
Thank you so much, John, for that comprehensive explanation about the changes in AS 4000. We do have one question that has come through, and that's in respect to GST and whether there are any provisions for GST requirements in a situation that the contractor is not from Australia and is doing work in Australia as part of the work under the contract.
There are no specific provisions that have been inserted to deal with that. There's nothing more I can say about it.
Okay, thank you. We have provided this. Oh, there's one other that just came through. Has the 2025 version of AS 4000 been issued to paying members? I have only been issued the 1997 copy as recently as June this year. I can probably take that one. Joe, I would suggest getting in contact with the Standards Australia store team that is responsible for licensing. I will put the link again into the chat so you can have access to it, so you can get an updated version of the document. One other question that has just come through, John, I think that's for you. Does the updated contract allow for a nominated rate for contract variations?
It allows for a rate to be nominated from memory, and if there's no rate selected, I think there's a default provision provided for.
Thank you.
I'm happy just to check that if you give
okay,
me a
yeah,
moment.
we just monitoring the chat, see if there are any further chats, any further questions coming through.
I just need to find the relevant item in the annexure.
That's fine. There's another question that has just come through. So let us know when you're ready, John.
I can probably take the other question while I'm doing this.
Okay. So what's the benefit of adding the formal instrument of agreement?
It simply deals with two issues. One, it saves parties having to go and find a formal instrument of agreement as published by Standards Australia, or to create their own, or to take what Standards Australia has offered in other forms and amend it. It also removes the possibility that parties won't actually prepare and execute a formal instrument agreement. So it's an attempt to try and remove the risk of them not properly forming the contract in a written document. And it was seen by the committee as a good move to include it all in one document, so that it was easy for users to be able to totally formalise the creation of a contract.
Great, thank you. One other question, are there any plans to update to further reflect risk provisions such as consequential loss and limitation of liability, which are common in industry?
Do you want to?
I'm happy to take that one. So
I
I think I made reference to these at the very beginning of the webinar today. We have received feedback from industry that there is, further opportunities for further updates to AS 4000. We really wanted to get these revision done and published, and we're going to be working with stakeholders on further changes in the near future. So we're just starting this consultation process. We welcome any feedback from all users and our stakeholders as well as to what are the other opportunities for further updates to AS 4000. There is another question here of when is 4905 to be updated. I understand this is one of the standards in the suite. So the committee and our stakeholders are looking at, there are several documents in the general conditions of contract suite, and we're looking at all the priorities and consequential amendments to all of those standards. My understanding is that there are two, they're underway, in particular the handbook that accompanies AS 4000, and all of those consequential revisions will be taking place as well. I can't give you an exact estimate as to when 4905 will be updated. As you would imagine, there's quite a few of those that need to be looked at, but we are working through the entire suite. Okay,
Kareen, if I can just come back to that question. The current draft requires variations to be priced in accordance with clause 36.4, which provides the, in a similar way to the previous version, a regime of pricing. It's by way of prior agreement, failing that applicable rates or prices in the contract, failing that rates or prices in a price bill of quantity, schedule of rates or schedule of prices to the extent that it is reasonable to use them, and failing that reasonable rates or prices, and states which must include a reasonable amount for profit and overheads. There is no default percentage. It then goes on and says any deductions must include a reasonable amount for profit, but no deduction for overheads. And then it goes on and provides that the price of all variations is to be added to or deducted from the contract sum.
Great. Thank you. Thank you for coming back to it. So one other question. I note the 5 new dispute resolution options, but could you please restate the new dispute resolution default process?
It's negotiation followed by either arbitration or litigation to be selected by the parties. Should they fail to select between one of those two, then it goes off to litigation.
Thank you. How are provision sum items recommended to be included in the new version of the contract? What's recommended further to lump sum items and schedule of rates?
Sorry, could you just repeat that, Kareen?
How are provision sum items recommended to be included in the new revision of the contract?
There is still a provisional sum provision. So in that regard, from memory, there were no significant changes made to the previous draft. Okay.
And we can confirm that at the end of the webinar if there are any other questions that we're unable to address.
Yeah, sorry, just to confirm that there are some drafting changes because of the way matters are being defined or terms are being defined, and in order to make it a little bit easier to read, but the same process as regards the pricing of provisional sums that was in AS 4000, in the previous version of AS 4000, hasn't changed.
Great, thank you. There are a few questions here in relation to whether there is a transition period to use the new 2025 version, or how long can we continue to use the older version, and can you still be using the AS 2124 as it's still available, even though it has been superseded by AS 4000? Can it still be used? Would you like?
I think maybe you go first on this one, Kareen, and then I'll make some comments.
Yeah, so from a Standards Australia perspective, the technical committee is obviously indicating that AS 4000 2025 version has essentially replaced the previous version because it's more up to date. But ultimately, standards are voluntary unless they're referencing regulations or contract instruments or procurement requirements. It's really up to the parties to make a decision as to the version of the standards terms of contracts that they wish to use. But John, from an industry perspective, you might have a different perspective or a different take on these.
Yeah, so I'll make the simple observation that the committee worked very hard to ensure there was no change to risk allocation from the 1997 version to the 2025 version. It also worked very hard to update the document in terms of changes that have been made to legislation, and I've mentioned a number of them. It worked very hard to change wording to ensure that uniform languages were used throughout, that antiquated language such as thereof was no longer used in the document. the documents no longer, for example, referring to clauses and subclause. It uses a uniform approach of just a clause, referring to clause, and then has a number, whether it's a full number or a paragraph number. And it also includes the addition of the options on dispute resolution. So from my point of view, I don't understand why someone wouldn't want to shift to using the new version, given that it's incorporating all that work. And the problem with not using it and staying with whether it's 2124 or AS 4000 1997 is that you've got to think about adding in GST clauses, PPSA clauses, dealing with principal contractor, dealing with some of the uncertainty that sits around, for example, the adjustment to quantities. And I know that was somewhat complicated, what I tried to explain, and it is complicated, but we've dealt with that uncertainty. We've also dealt with uncertainty around qualifying cause of delay and around the ability to issue a certificate of practical completion with a date in it which predates the date on which the certificate was issued. I think that answers the question.
Thank you, John. Much more eloquent than my explanation from a Stamps Australia perspective.
No, not more eloquent, just a little bit more detail around some of the changes that have been made, Kareen.
Perfect, thank you. So there are a few more questions. Has there been any changes to insurance requirements, or is this down to each project specifics?
There weren't any significant changes from memory to the insurance provisions other than those that go with making sure language throughout the contract is consistent. And it was seen by the committee that there was no need to make any changes, and to the extent that a particular project might have specific needs, that they would need to be reviewed anyway.
Great, thank you. A question as to what drove the decision not to contemplate unfair contracting provisions?
I'll answer that very briefly. Consideration was given to the applicability of the legislation governing unfair contract terms, and the view was very much taken that it is a matter for the parties themselves when entering the contract to deal with.
Great.
I should also add, the view taken by the committee was it did not want to change the risk allocation because industry and those represented, or those parts of industry represented on the committee, formed the view very early on in the process that the risk allocation in the AS 4000 1997 document was appropriate and should be retained.
Thank you. Have you looked at moving the contract closer to collaborative principles in other standards contracts?
That was discussed. The view taken was that that would be a step which would involve a change in risk allocation in the document and should be left for another day, or should be left for the parties to deal with themselves.
Thank you. Hi, John. I wanted to ask, what are the updates that will benefit contractor or safeguard contractor interests? I have seen employer keep their interests first, transferring risk to contractor often. The risk allocation.
I can't stress enough, there was not a view taken that changes should be made to favour one part of the industry over another. The view taken from the outset and maintained throughout the entire review of this document was that the risk allocation that existed in AS 4000 1997 should not be changed. And so the only areas where changes were made were along the lines I've outlined, which was necessary to bring the document in line with legislative changes, to clarify any uncertainties that existed, to fix up language in the document that was different in different places.
Great, thank you. What was the rationale for including the appointment of a principal contractor for WHS option? Was there uncertainty under the previous version?
It simply wasn't dealt with, and it was seen by the members of the committee as an important thing to provide for, and it's an opt-in provision in that the parties have to state that the provision applies or the clause applies, and define to which part of the site the clause applies. So it's not mandated on the parties if they accept the document, they have to opt into it.
Great. There is one other here. Has provision been made to attach annexure such as specification, construction schedule, etc.?
There is, in the formal instrument of agreement, an ability to add other documents to the contract. So the answer to that is yes, by virtue of the formal instrument of agreement that has been included within the document.
Right, thank you.
Sorry, I should add one other comment. Depending on what's being added and the reason for adding it, there may be a need to make further changes to the contract.
Okay. There are several questions as to whether Handbook 140 will also be updated.
I can assure you it will. We are currently working with, we at Jones Day are currently working with standards to update that handbook. It is a significant task and it's underway. And the committee will be involved in that as well in terms of a review and providing comments on it.
Yeah, absolutely. So as soon as possible is the answer. But as John has mentioned, it's quite a substantive effort, but we'll get that to all of you and made it available as soon as possible. There are a few other questions in relation to the changes here, John. So clause 1, definition of qualifying clause of delay, notes any act, default or omission of the superintendent. What specifically is defined as an omission?
It's defined by the common law. It's not defined in this document, and the common law takes a very liberal view of omission. It is not necessarily an unlawful omission. It can be a failure to do anything. Great.
I think you might have touched on this before, but I'm gonna repeat this question just in case.
Sorry. I should make one other comment, Kareen.
Yes,
the committee didn't even look at whether a definition of omission should be included, and that's not unreasonable given that it's a clearly defined word in the English language.
Great, thank you. So the question was the principal contractor clause added to address uncertainty or because it was not dealt with at all under the old version?
It was just not dealt with.
Yeah, I thought you had already mentioned that
and it's worth making the comment that almost every contract you see nowadays where the site is or part of the site is being handed over to the contractor involves a consideration one way or the other as to what should happen to the principal contractor role given how that legislation affects workplaces. Great,
thank you. So there is one specific question here around your example of lower limit of 80. Is the variation is for the 80 or the difference between the BOQ quantity minus 80? I think that's the question.
And it's a very complicated provision. I can understand why that's been asked. No, the 80 becomes a deemed variation. So just to explain it again, if the stated quantity in the schedule is 100, and the actual the limits of accuracy which the parties have selected is plus or minus 10%, then the lower limit is 90 and the upper limit is 110. If the actual quantity is 95, there's no adjustment. You just use the rates. If the actual quantity is 80, then the whole 80 is a deemed variation. So you've got to reprice the whole 80. Which might mean, depending on how the contract sum is being instructed, it might mean a reduction and then an addition. So a reduction of the 100 and an addition of the 80. If the 80 is, if the relevant quantity is just being added on, then you would just add the 80 on, but it wouldn't be the price that was given for the 100 necessarily. You'd need to consider the formula that I went through before as to how you price a variation as to what the relevant price of the 80 units should be. At the other extreme, if it's 110, then the new clause is now saying, well, you price the whole 110 using the relevant rate under the contract in the schedule rates or bill of quantities that forms part of the contract. If it's 120, then the 110 gets priced using the rates because it's within the limits, and the additional 10 becomes a variation.
Great, thank you. Well, I think you mentioned this one, but it popped up again, so might be worth just answering it one more time.
Happy to take it.
With the changes in the contract sum clauses, is there any provision or changes in regards to provisional sum?
there is still the ability to provide for a provisional sum in the contract, in one of the contract documents. And if that happens, then clause 3 will potentially apply if a direction is given to perform the work, the subject of the provisional sum. So what the drafting provides is that no provisional sum which is included is payable by the principal. So if you have included one, then it's not automatically payable. But if the work, the subject of the provisional sum, is directed to be undertaken, then clause 3 deals with how it's priced.
Great. Thank you, John. A few more questions. How are design components undertaken by contractors as part of their works handled? For example, if AS 4000 2025 is used for partial D&C works?
I think the simple answer to that is AS 4000 is not intended to be used where D&C work is being carried out.
Okay, thank you. This is an interesting one, maybe a little bit outside of the scope of the changes, but a question for you, John. Do you have any views on the alignment between these changes and the New Zealand Standard 39,000 update?
I haven't done a comparison, I'm sorry.
Okay, no, that's good. There's one other here. So generally, client heavily modified standard clauses with specific clauses like qualifying, clause of delay, clause in their favor. How lawful is this? Their modification doesn't give us any room for delay cost claim.
The answer to that is not something which has been dealt with by the committee, nor should it be. It is going to depend on the nature of the changes made and a whole host of issues, including whether they're certain in terms of how they've been changed, or whether they've created uncertainty, whether they're unfair contract terms, and could even go to other pieces of legislation to the extent to which that legislation might impact whether a particular clause is valid or not. So it's not something I can answer with a general answer, Kareen.
Understood. I think that makes perfect sense. So there's an interesting one here. If there was another COVID type event, how does the contract deal with it?
That's going to depend in part on what happens in terms of legislation or regulations issued by our legislatures and authorities, or directions given by our authorities. It's also going to depend on what happens with definitions like qualifying cause delay and how the annexure is completed. So once again, it's going to be very fact specific and depend on how the contract is completed.
Right. One other here, does it address early occupation ahead of PC? I have to say I don't really understand that question, but it might make sense to you, John.
I don't think no changes were made in that regard, and I'm going off memory, but the previous version didn't address it, so I'm pretty confident it's not addressed in this version. Happy to have a quick look at that.
Great. So I think most of the questions that are left in here, they relate to the first one is in relation to whether we will be sharing the sessions and the transcript and the recordings. Our team has already replied that yes, the recording of the session will be shared with all that have registered for the event. There are also some questions as to how those changes are going to be communicated to industry, and also how if there are any plans for industry uplift around the contract. I mean, from a Standards Australia perspective, this is our first event to be able to kind of share and socialize all of those changes. We are very keen on planning further updates. So if this is something that generally there is a greater need, which seems to be the case, we will certainly be considering further updates. I think there's suggestions in here as to whether that could be specific information on all of those changes that John presented today. We'll work through that and provide in due course. A few more questions coming through. We still have time for more. So there is a question here. Would there be enough resources to be able to understand superintendent roles and responsibilities?
I think if I understand that question correctly, the updated handbook will certainly provide some help in that regard.
Great, thank you.
And I should also add the role of the superintendent hasn't changed in any significant way under the new version or the updated version.
Okay, thank you. So someone has put it in here. Apologies if this was asked earlier, but does the AS 4000 contract address conflict with the Building and Construction Industry Security of Payment Act? Does the Act override payment terms in the agreed contract?
I'll answer this in two ways. When the review was undertaken way back in, it was either 2022 or 2023, to determine what, if any, changes were needed to be made to this contract to conform it with the relevant security payment legislation around Australia. The view then taken by the committee was that there was nothing needed to be done to the document. It was also decided by the committee that by trying to hardwire clauses into the document which dealt with that, it would carry with it the problem that should that legislation, which exists in slightly different formats in different jurisdictions, or even more than slightly different, should that legislation change, and there would be a need to come back and do a revision of the AS 4000, and we'd end up with another update. So the view the committee took was not to deal with it.
Great, that's helpful. Thanks. I guess there's another question around, future review, and essentially saying in the next review, which hopefully adds and improves a lot of contract terms, would something like force majeure be reviewed?
I can't recall whether specifically force majeure was considered. My recollection is that it was, and the view was taken that it was adequately dealt with by the extension of time regime. And I might just make a comment on that. I have seen a number of contracts which have inserted just a rather typical, to the extent you can call them typical, force majeure clause from a commercial contract into a contract like AS 4000. The problem with that is it creates a mechanism which sits side by side with a very carefully drafted extension of time regime and covers the same, if not more, territory. And you then end up with the issue of, well, if the force majeure clause applies and the extension of time clause applies, and the contractor doesn't seek an extension under the extension of time regime in the contract, can they still do it under the force majeure regime and be relieved of their responsibilities? It's something which should be treated with care. From memory, and I'm going back over many months of meetings, I think it was either dealt with in a committee meeting because someone in the committee raised, or it was raised in the public consultation process, and the view taken was that there was no need to deal with it in this document.
Okay. Thank you. We're nearing time. There's one other question here that has come up already, and I'm sure that neither of us are going to be able to provide a specific date, but there is a question as to when is the new handbook expected to be updated and released?
Kareen, I had a discussion yesterday with your colleagues from Standards. We're currently working through a timetable on that. There is a process to be gone through of us making amendments, taking further instructions from Standards, and then going to the committee. So it's going to be a number of months.
Yes. Okay. But it's in the making. So stay tuned.
Yes.
We will try and speed through as much as possible, but obviously there is a lot of work that needs to be undertaken. All right, I think that's it from us. John, my huge thanks from us, one, for this session. You're on the firing line of a bunch of questions. Thank you so much for addressing all of them, and thank you for your and your team's work in drafting this revision. I also want to acknowledge and thank the members of our technical committee, MB10, that are responsible for this revision. They have invested a lot of effort, time and effort, and their knowledge to see this document updated. And also the Stands Australia team that has worked very tirelessly to bring this update to fruition, and also is continuing to working with our stakeholders for further updates on the series. I just want to reiterate this point. So Handbook 140 is being worked on at the moment. I believe 442, there is one other, I should have got the number right. So 4902, General Conditions of Contract for Design and Construct, is also being revised. Again, no timeframes just yet, but these are the two priorities following AS 4000. And we'll be working through the entire suite of standards as well. So many thanks for joining us today, for your engagement and your questions. I wish you all a great afternoon, and thanks again, John.
Thanks, Kareen. Thanks, everybody.
Thank you.